Hello, everyone. Welcome to the FSBPT webinar on Let's Make a Reinstatement Statement. I am Michelle Sigmund Gaines. I'm the Executive Director for the Oregon Board of Physical Therapy. Honored to serve on the Federation Board of Directors, which means one of the things I get to do is introduce Dale Atkinson. And so with no further ado, I will turn it over to Dale for today's webinar.
Hey, well, welcome everyone, and thank you, Michelle, for that introduction and to this February reinstatement statement seminar here. And as I like to start every one of my presentations out, and it's with a big sincere thank you, so a big thank you goes to the board of directors for dedicating the time and their service, their volunteer service to allow these bi-monthly seminars to take place. A big shout out thank you to the staff of FSBPT for operationalizing this and handling a lot of the issues related to questions and others that might surface. But the biggest thank you goes to each and every one of you who are on the line today. Whether you're executive director, administrator, a volunteer board member, governor appointed, whether you're an investigator, an inspector, an assistant attorney general, I don't believe the regulatory community is recognized enough, and I want to reach out and at least give you all a big thank you, not only for being here today, but for what you do in general in regulating the profession in the interest of public protection. So big shout out thanks have to go to each and every one of you as well. To make sure that you're listening and paying attention and that you're technologically savvy and all that, we always start out these discussions today, or these discussions on these monthly discussions with some pictures or other things, just to challenge you and also make sure that you're there and to make sure you're listening and to make sure you're willing to participate, because participation is a big important piece to these facilitated discussions. And so who are these cats that you're looking at on the screen? So somebody type that in there. If you don't know, you don't know. Just type something in there. Regulators, by the way, are cool. And so okay, we got a don't know here. So okay, so you're kicking that off, and Mindy as the first one to submit a chat, you might win a prize. So Rich will send you a nice surprise. Oh, before my time. So that's a really good point, the before my time, from the standpoint of the demographics of those who are listening in today and who we would like to participate as well. So these are Bob Marley's kids. And definitely reggae. Well, I like the Cool and the Gang too, so sign there. So we're into music, we're into these pictures, we're into the historical side of things to get us going here. And to keep us going here, go ahead and type in who you think this is, and then you can type anything else you want into. Okay, well, right away we got an underdog, so well done. And so we want to keep these chats going. A big part of what I like to do is to ensure that you all are receiving information that's beneficial to you, and the way to do that is to have you participate. And while I'm on that topic, while we try to lay out topics in advance for the year of what we're going to talk about every other month, we welcome comments from you all as to topics and other issues that are surfacing within your jurisdictions that we can bring to the attention of the FSBPT family and have facilitated discussions about those as well. So feel free to send any ideas to Rich and Jeff, and we can work those into some of the subject matter in the upcoming months as well. So we've got coming to save the day, and hopefully that's what we all are doing as regulators is saving the day. And yes, that is underdog. My name is Dale Atkinson. I'm an attorney in private practice, and I represent a whole bunch of FSBPT-like organizations. This is my 38th year of representing groups like yours and being involved in education discussions, facilitated discussions, sometimes a lecture here and there. But the point of all this is it's not necessarily about me, it's about you. And it's about you to show, one, you're not alone, and you have your fellow board members on your board, you have your fellow boards within the intra-state system that you have, and then you have the interstate other other physical therapy boards that exist. And so take advantage of your relationships that you have both intrastate and through FSBPT. It's really critical. And I applaud each and every one of you for being here. And this is part of what these types of relationships can help build. So I represent a bunch of groups like FSBPT. These are not-for-profit organizations. Their members are comprised of the regulatory boards of the professions of the U.S. jurisdictions, territories, districts, and many of my clients are more international. They're North American, the Canadian provinces, or otherwise. And most of my clients develop, administer, score, and maintain a uniform licensure exam program. So hopefully my remarks are relevant to your world. I do a lot of these types of trainings and other lectures and facilitated discussions. So I'm hoping that I can bring some important topics to light today on our reinstatement discussion. But I do depend upon you all to type things into the chat and make comments that you think are appropriate and ask questions or anything else. So let's start with, what is reinstatement? And the title is, also included reentry into practice. And, I think there's a big difference between the two, but anybody wants to type in the chat, or by the way, if you want to unmute and speak, feel free to do so. Rich and the staff are keeping an eye on the on hands that might be raised, or if you need to unmute, feel free to do that. But, what is reinstatement? Okay. And what is reentry into practice? And how might we define those? And I think it's difficult to define it in a vacuum, but we all kind of know it. And we all know it when we are confronted with it and when it surfaces, in that it's someone who previously had a license, no longer has a license, and is seeking to reinstate that license for whatever reason. There does not necessarily have to be nefarious reasons that the license, so to speak, went away. And then the second, and we're going to get into this obviously in more detail, but the second part of this is well, what is reentry into practice? And is there a difference? So if I maintain my license in your jurisdiction by getting my CE, paying my renewal fees, but I don't practice, do you care? Or if I choose to not renew my license and I allow it to so-called expire or lapse, or whatever terminology it is that you use, I'm out of practice for a period of time, but now I want to re-enter the practice of physical therapy or as an assistant. And is there a difference between these two? I think yes. But at what point in time am I being deemed to no longer be able to lawfully practice because I don't have a license? So if anybody wants to type into the chat, if I have a license, I get my CE, I submit my renewal form and pay my fee, but I never practice. Do you care? Is there a basis? Is there a requirement that I'm in active practice? Now, I'm going to pause here for just a second and get a little bit off topic, because in endorsement statutes, and everybody understands, by the way, that reciprocity endorsement, licensure transfer, whatever you call it, there's really no such thing as reciprocity. We need to talk about endorsement. So your endorsement statutes might say that I've been licensed for 5 years, I've been in active practice for 3 out of the last 5 years in order to qualify to actually endorse into a second, if you will, jurisdiction. So we've got a couple of comments coming in as, yes, it sounds like a good idea, but may not be required in law in AK, Arkansas or Alaska. Reactivating lapsed license less than 5 years. So now here's a reactivation and a lapsed license. We're going to get to these in just a minute. And flush out at least some of these issues that might surface as well. So in California, reinstatement is returning to practice after discipline. Reentry would be somebody returning after being away from practice. And so the California question there, Carol, is being away from practice, does that mean with an active license, but I don't practice, or does that mean my license is no longer so-called active anymore? And I know in some jurisdictions, we can elect to be inactive, not have to get the CE, pay a lesser fee, but we also can't practice. And then do we reactivate that? Is that a reentry question? So I will say this, as I was preparing for these remarks today, I thought, okay, reinstate me. I like the topic. It's a great topic. And I thought, an hour we have basically, or a little bit less to give some questions and answer time. And then I realized as I got into it, we could probably talk about this for hours if we tried by getting into these types of questions that may have surfaced. So keep those chats coming. And I see a few others as well. And if a question, Rich or Jeff, crops up in the chats, feel free to interrupt me. I'm trying to watch them, but I'm also seeing my slides as well. So reinstatement parameters, let's focus on the reinstatement for a minute. And the parameters, where do we find those? They're going to be set in law, right? I suppose they might be in statute with additional meat to the bones of that statute through regulations or rules, regulations, whatever they're called in your jurisdiction. Many times, or perhaps more likely, they are set in a final adverse action order. And we're going to talk about the elements of that order in just a couple of slides, but there may be other reasons. There may be common law issues at stake here too. Common law just being judicial decisions that evolve and help set what that law might be in terms of regulating a profession. So we're going to look to the law. We're going to look to the case law. The law, we might look at the statutes and regs. We might look at the case law. And then we also, very importantly, are going to refer to final adverse actions that may have existed that set the stage for this reinstatement post finding of wrongdoing. So that's generally where we want to focus and where our minds will go, but it's not always necessarily that as well. So we've kind of set the stage here, but we'll pause for just a minute on why was the license removed? And is removed the right word, by the way? Why is the license no longer active? Why is the license no longer valid? And when did this all occur? So how much time has passed? Again, very important issues related to reinstatement and re-entry into the practice after being out for a certain period of time, whatever that is. And those periods of time are going to vary from jurisdiction, potentially vary from jurisdiction to jurisdiction. So you need to check your laws, your statutes, and seek legal advice where it's relevant. And so follow the advice of your counsel while I'm on that point. So I'll pause there for a minute. So now, so why was the license removed, if you will? So an adverse action. We've emphasized that a licensee is subject to a complaint. Rights are wrapped around the property interest in the license. There is a ultimate disposition of the complaint, and the license is somehow removed, suspended, revoked, or any other adverse ruling or adverse finding that the license is subject to. And as I've mentioned, and I want to emphasize this, and that is how that final order and that adverse action is drafted is extremely important to set the stage for future board members that are going to have to perhaps make a decision on eligibility for reinstatement. So let's go to the next one, is non-renewed. And, the next two bullets, lapsed, expired. What happens if anybody wants to unmute or type it into the chat? What happens if I don't renew my license? And, it expires, I suppose. I'm no longer authorized to lawfully engage in the practice of physical therapy or as an assistant. And, but what do you do as a regulatory board? So in Arizona, it's administratively suspended, okay? So it's probably automatic too. It's likely I don't get a hearing or otherwise, but if I am silent and you do not know what my intentions are, I may have moved, I may have retired from the practice or anything else. Does it change? Does it matter why I am not renewing that license itself? And then while we're having people type in here too, so we've also got a comment on it's not a licensee with privileges of one, it lapses, so we notify. So it lapses as in, again, it's considered no longer valid, and you cannot then engage in the practice. So while we're kind of typing into these chats and all that, how many jurisdictions, if you have this, just type it in, but you have an inactive status. So can I elect to go inactive? And there's a big difference, by the way, between I'm silent and you as the regulatory board don't know what my intentions are, versus I elect to go inactive, assuming such status exists, and I check that box, and now I'm in an inactive status. Therefore, I can't practice. I'm not subject to perhaps the CE, but I can reactivate that license by following whatever the law says related to that. So I don't see any chats yet coming in on that. So I don't know if so some jurisdictions like don't have the ability to go inactive. Some do, and some don't, and that's pretty much the case across the professions as well. So is it a reinstatement if I go inactive, if I'm allowed to? So not in Wyoming, North Carolina doesn't have that either. So many of you do not have that status. And I am very much into your board having all the information it needs to make an informed decision, whether it's to issue a license, renew a license, or remove a license. And silence is a difficult issue for you all to deal with if you don't know what Dale's intentions are. Again, moved, maybe I passed away. And so there are so many different factors that need to be taken into consideration. And can you modify your application for licensure and renewal to try to address some of these, where even if you don't recognize an inactive status, that you allow someone to check the box that they are not renewing their license, so-called, let's call it voluntarily. They're choosing not to, as opposed to any other reason that might exist. And then the last bullet on this slide here is the voluntary versus involuntary. Involuntary to me is an adverse action. My license is being taken and I don't want it to be taken, versus I voluntarily choose to go inactive or don't renew or anything else. And so you all could probably make a much longer list than I as to the so-called removal, excuse me, these removal factors of why that license is no longer valid, if you will, or active. So you think about that, and once you establish that, it starts to help answer these next questions. So let's just pause here for a minute and talk about final adverse actions. It's critical. Your lawyers should help you on all this, but it's good for you all to know what the elements are to a final order. And a final order can be, by the way, after a hearing. It can be a consent order, and it's going to cover hopefully all of these elements, which would include findings of fact. And again, most jurisdictions are driven by complaints, right? You are a complaint-driven regulatory agency, and a complaint comes in, you investigate, and you resolve it in whatever way you resolve it. So you have findings of fact, conclusions of law, and then the burden of proof. So preponderance, clear and convincing evidence, whatever it is, you put that in this final order. And technically, that should be the very first sentence, by the way. By a preponderance of the evidence, the board hereby finds the following. And then you have everything in there. Now you're telling the world you know what that burden is. And I'm always surprised when I see cases that get appealed. And one of the issues on appeal is, what is the burden of proof? So you're going to want to know that. You're going to put it in the final order. So facts, conclusions of law, burden, the sanction with specificity, whatever is going to happen to this individual, suspension or otherwise, with monitoring or anything else that might be administered here, as you put that in this final order with specificity, so anyone who reads it can understand what this licensee or now sanctioned licensee are subject to. And then the highlighted one there next is the reinstatement rights, if any, and with specificity. How am I going to get this license back again? And there'll be a slide about revocation. I'll bring it up now. So what is revocation? Think about that for a minute. We're going to get to that in a slide. But what is this sanctioned license now subject to reinstatement? And if so, how is that going to be reinstated? Meaning, what am I subjected to successfully show the board that you should reinstate my license? That should be in these orders across the board, so that everybody knows what happens tomorrow. And tomorrow, by the way, keep in mind, might be 5 years from now. And you have new board members, you may have new administrative staff, you have new assistant attorney general or attorneys representing the board. And we should be able to read that order from 5 years ago and know exactly what it takes to allow this individual to reinstate their rights here. So hang on a second. The last two issues, publicity. It's going to be posted on the website. It's going to be sent into the data bank for FSBPT. It's going to be sent into the National Practitioner Data Bank, whatever it is. You put the publicity and the right to an appeal. Obviously, a consent order may not have that right to an appeal, but a consent order also has all those other elements in it so that everybody knows what's happening today and what might happen, or more importantly, what might not be able to happen tomorrow. So it's very important in a reinstatement discussion to make sure we know what these final adverse actions, how they should be drafted, what they should say to help everybody else out. So I allow my license to lapse. I wait 5 years. I'm raising a family, whatever the non-nefarious reasons are, and I want to get back into practice. So if anybody wants to unmute and answer this question, well, does it become a new license? And do I do I apply for that so-called initial license, even though I was previously licensed? And does it matter as to the amount of time that goes by? Does it matter as to what the law may now say versus what the law said last year or the year before? If issues change, now what do we do? And I might suggest to you that it's always a reinstatement. It's not a new license. And so I see Michelle is putting in there after 5 years, it's a new application. And I hear that a lot. And so here's what I suggest is that we all reflect upon. If it becomes a new application, and Michelle, if I get this wrong, you can correct me. Same license. That's where I'm heading right there is if it's a new application, that means the current law applies. So if there's a new educational standard, a new examination standard, a new experience standard, a new good moral character standard, that's what must be complied with. But you issue the same license number. And I agree with that wholeheartedly. So it may be a new application, but the same number. You do not want to issue new license numbers and then have confusion in the future as to who this individual might be. And you don't want anything to fall through the cracks, obviously, of course, as well. So I like to at least say it's always a reinstatement application. I understand the Oregon nuance there. There may be a new application, or it may be subjected to the current laws. And those laws do change, obviously. And like I said, it might be a big change too. It might mean I have to go back to school, or I might have to retake an examination or otherwise. And so think about that and think about how that might apply in your particular jurisdiction. So we've kind of addressed this, but if I don't renew, what does your board do specifically? Your law may say something, I don't renew, there's some grace periods or otherwise, and now what? Okay. And I've already said, I jumped to that conclusion. Well, your license is now expired or lapsed, or you tell me the name you use, the phrase you use, and I can no longer engage in the practice. But what else happens? Does the board do anything? Are orders entered? And if so, what happens to those orders, and what do those orders say? And so, again, this is a very important point to help us decide, well, what about the reinstatement somewhere down the road related to this? Now, and this is why I'm all the way back to an election to not renew. Even if you don't have an inactive status, I would be thinking about, can I fashion my renewal notices and my renewal applications to allow this election to say, I'm choosing not to renew? And you could also, by the way, have an attestation right on the heels of that that says there are no complaints pending or anything else, so that there's no non-renewal to thwart an administrative investigation or otherwise. But and usually this upsets people, but I'm going to say it anyway. What I usually suggest is that those that don't renew their license, there's a final order entered. So, and if you have a December 31st renewal, you have a couple month grace period at that March or April meeting, you enter an order that says the following 10 people didn't renew and their licenses are now, and you put the word in there, expired, lapsed, revoked, suspended, whatever it is you think is appropriate under your law. And then that is a public order. So the consumer, now can go to your website and see that, that someone's license has not been renewed. I don't need to draw a negative conclusion out of that. I can say this person may have elected not to renew for whatever reason that might exist there. But it creates a record that can be followed so that future boards then know exactly what happened as well. Now, you may or may not agree with that approach, but it's a conservative approach that says the consumers have a right to know and make it easy for the consumers to find out. Dale's license wasn't renewed as of the 90-day, and I see Connecticut has a 90-day grace period. Okay, so as of on the 91st day, Dale can't renew that license anymore, and he's subject to some other process. But on that 91st day, an order is entered that says Dale can no longer lawfully engage in the practice of physical therapy or as an assistant in Connecticut, for example. And I don't see anything wrong with that. And I have no problem that being an adverse action, if you will, because when I move from Connecticut to New Jersey, and New Jersey says, have you ever had a license? Yes, I have my Connecticut license, and I allowed it to lapse or expire. It was subject to a final order. New Jersey can double check that. They can go to FSBPT in the data banks and can say, great. And then they process your endorsement application or whatever it is I'm doing in New Jersey. And it's all about knowledge. It's not about drawing judgmental conclusions that say, well, he must have done something wrong in Connecticut. So I think if we can avoid the conclusions that might be drawn about a lapsed license being a bad thing, maybe we can improve the systems, and instead of dissuade people from disclosure, they are not afraid to disclose that, yeah, I allowed my license in Connecticut to lapse, for example. and there's obviously nothing wrong with that. So think about that. If anybody else wants to unmute or type in the chat, what do you do with non-renewals at the end of the grace period? Many of you probably don't do anything. And I see in Arizona, there is no grace period. It's administratively suspended. It's posted on that day. So now the public has a right to know. Okay. And the word suspension, that's going to draw, certain conclusions judgmentally from both practitioners and perhaps consumers. But that's what the Arizona law says, I'm assuming. So it's considered suspended. And are there other ways to address situations that don't make it feel like it was based upon a wrong act, if you will, that was undertaken? So think about that. And while this is on the front end, and the topic today is reinstatement, this front end is so important to determine what about this reinstatement and what are we going to end up doing. So, all right. So now that all important question, what is revocation? So your license is now no longer valid. We'll start with that, but it's been revoked. So is it no longer exist? Is it an adverse action against the license? And the most important question for today's topic is, can a revoked license be subject to reinstatement? And the answer to that in probably many of the jurisdictions would be yes. Very few jurisdictions, revocation means never having to say you're reinstated. Very few jurisdictions is revocation a permanent finding that says Dale can never practice in this particular jurisdiction ever again. Dale can never have a license in this jurisdiction ever again. Now, with that said, if your laws are silent about it, which many of them are, and you have an egregious circumstance that exists, set of facts that you wish to, your board wishes to permanently revoke. We're going to go all the way back to that final order, and it's going to say on the sanction side, permanent revocation, not subject to reinstatement, or whatever. There'll be language in there that tells the respondent the licensee now, the former licensee, and it tells the rest of the world, including future boards, that this license is permanently revoked. So if the law is silent and you want to challenge and you want to impose that, go ahead and let it be challenged, and the courts will eventually decide. Again, it's likely going to be a very egregious set of circumstances. So with revocation, though, in most jurisdictions means that it is subject to a reinstatement petition. And we need those orders drafted properly to avoid the harassing type reinstatement petitions, because a poorly drafted final adverse action order doesn't explain when can I seek reinstatement. So if I were representing a licensee who was subject to revocation and the order was short and didn't contain all those elements we talked about, I'd seek reinstatement the next day, perhaps the next month. And you all are going to say, no, not enough time has passed. I'm going to say, I want a hearing. Now I'm just a thorn in the side of the regulatory board here. I'm probably wasting your time, but a lot of that is premised upon the fact that the final order perhaps wasn't well drafted, or it didn't include the specificity that we all need to know what to do tomorrow based upon the revocation today. So I talk about this a lot. I talk about revocation and all that, and I would say this: I might not revoke a license unless I intended it to be permanent. And I would use the suspension approach, because suspension, well, let's stop for a minute and say revoking. Now let's go back to our definition of revoke. The license is gone and no longer exists. That means perhaps your board has no more administrative jurisdiction over me. I don't have a license anymore. So if I continue to practice and your laws are not specific enough to allow administrative action against unlicensed practice, there's a criminal issue at stake here, but let's push that aside for a minute. Now you've revoked a license and you've revoked yourself right out of jurisdiction. I think somebody wants to ask a question. Go ahead. Kathy, I think you had unmuted. Oh, whoops. Okay. Very good. So revocation has consequences, obviously, to the licensee, but perhaps to the board itself. Now, back to that suspension question. Well, if you suspend, you now have a license subject to suspension, subject to a final order well drafted. You know you have jurisdiction over that individual administratively to continue to enforce the adverse action in the interest of public protection. So, this revocation question is a really good debate here, and it's very important on the reinstatement side, because can you reinstate a revoked license? That's the ultimate question. And you all can start to think about that and how it might play out in your jurisdictions. So, questions or comments about that, feel free to chat or unmute. While I'm kind of on this topic, there's no such thing as a voluntary surrender of license. Okay, a voluntary surrender of license is a consent order. So I avoid that phrase at all costs, especially in the world of reinstatement. Is if I surrender a license and the board says, great, we're not going to prosecute administratively. We saved ourselves a lot of time, effort, and money. We're going to accept your voluntary surrender. Well, now what happens tomorrow when I say, oh, I want a new license? Will you voluntary surrender? Well, where's the final order, and where does it describe what I can and cannot do? So if somebody says, I'm willing to submit my license, I'm going to surrender it, your answer is, here's the consent order, and you figure it out. And in the end, it's an adverse action subject to a consent order. And I see voluntary surrender still used by the courts and others when they're describing historical issues that have occurred with a licensee. But I would avoid that phrase, and I would just term it as a consent order. It is agreed upon resolution of a matter, and a consent order, by the way, for everybody, is just a contract. Two sides, they decide what's going to happen, and you lay it out in that consent order itself. So just a little bit of the revocation issue and voluntary surrender are kind of these Dale issues that I talk about a lot, and I perhaps overemphasize them, but hopefully it identifies for you all the questions. So back to now, how long out of practice? whether it's an adverse action or a inactive license or a non-renewal with a lapsed or expired license. Well, how long out of practice? So you're going to have to read your statutes. And we saw a few that said, 90-day grace period. Some might say 2-year period. Then you have to start over again and meet the new requirements. It might be a 2 or 3-year period. So you're going to have to figure that out. And now we may be talking more about a re-entry to practice than we are a reinstatement. If we've decided there's distinguishing factors. Do you have to reestablish competence after a period of time? Retake the examination? Yikes. Jurisprudence exams, ethics exam, or otherwise. Now, I recently moved, and I had to take the ethics exam that I had taken in 1984, and the scores from my 1984 exam were no longer available because of the passage of time. So for me to get licensed here in Utah, I had to retake an ethics exam. It's not a reinstatement or reentry to practice, but it's an issue that may be relevant in your world related to reinstatement or reentry. But what does the law say? And is it today's laws versus yesterday's laws? We're going to get to that in just a minute. So what rights are granted to a petitioner seeking reinstatement? I don't even want to call them a licensee. They're a petitioner. Hey, I want my license reactivated. I want it reinstated. And we've already asked a lot of questions. Well, why is it no longer valid? You're going to figure that out. And now you get here. Well, what rights do I have? Okay. Do I have a property interest in a revoked license? That's a pretty good question. And everybody understands what a property interest is. So when you grant me a license, I do have a property interest in that. Property interest just triggers a fair process to grant the license, renew the license, and potentially take it away. And that's what due process is. Due process is fairness, and it's constitutionally protected because the license is a property interest. Okay? If you revoke that license, now what? I no longer have a property interest in that license. So does that change the game? Maybe, maybe not. If you suspend the license, I have a property interest probably in that suspended license, and I'm subject to a reinstatement. And what rights am I going to be granted? In the end, you're going to grant these individuals due process, which is just notice, right to be heard, and a fair decision-making body, meaning no conflicts, if you will. So you should know that. You should be able to figure that out. But you should know the interest that's at stake, because that's going to tell you what kind of due process is going to be granted. And you give a hearing to a reinstatement petition. Do you have an internal appeal right? And there's always an appeal right into the court system. And then who has the burden of proof? And I, as the petitioner, would have that burden of proof. I have to show I meet the requirements for reinstatement, whatever those are. The new law, the meeting of the adverse order, the criteria in the adverse order itself, subject to drug testing, random drug testing. I had a psychological evaluation that. I've been to counseling or alcohol, an alcohol rehab program or something along those lines. I will have that burden to show as the petitioner I meet the requirements for reinstatement. You, as the board, the regulatory body, will make that decision. And mixed into all of that are some rights that I'm going to be granted, due process or otherwise. So it's good to know that, at least in the general sense. We're not trying to turn you all into lawyers, but it's good for you to have this basic knowledge, because then it allows you to ask the questions that may need to be asked of your lawyers and of your staff related to any petitions that exist. So what if the law has changed? And there's a couple of interesting cases that are coming up here. So what if the law has changed regarding education, exam experience, and most commonly, the law will change regarding good moral character or criminal history. There is a lot of legislative activity in the last several years that are starting to address criminal history, and when regulatory boards like yours can, and importantly cannot, consider historical information as a basis for granting or denying a license, or granting or denying a reinstatement petition. So what does the law say? What did it say then, and what does it say tomorrow when this petition rolls through the door, and how might that be applied? So if you all haven't heard about all this, you should start to speak to your lawyer about what changes in laws exist related to criminal history and or good moral character. So be thinking about that. And then the kind of the last point to prepare us for these cases that are coming up in the next couple of slides is retroactive application of a new law versus prospective application. The general rule is that laws are not applied retroactively unless the legislature specifically says they are to be applied retroactively. There's a lot of legal issues wrapped around that statement, but that's the short version. Most all new laws apply prospectively, forward, and you don't apply them retroactively. So a couple of cases here. These are reinstatement cases, both out of Pennsylvania. There's like a flurry of cases in Pennsylvania, I don't know why, related to reinstatement. These are dealing with human medicine. And so a little bit about the facts quickly of this case. These are both, by the way, 2023 cases decided, I think, relatively late in the year of 2023. But a physician who pled guilty to a violation of federal drug laws, conspiracy, fraud, and otherwise. And these violations constituted felonies, but they were not drug trafficking offenses. Everyone agreed to that. It's a felony, but it's not trafficking, okay? And trafficking in many jurisdictions criminally is a much more severe issue than violation of drug laws that exist. So the Pennsylvania law at the time of his conviction required an automatic suspension and a 10-year wait period for reinstatement of license. So that's interesting now, okay? So an automatic suspension based on a criminal conviction with a mandatory 10-year wait period. And by the way, they're not entitled to a hearing, right? Because they had their hearing. They had their criminal activity and their criminal trial that may existed, or in this case, it was a guilty plea. But either way, they had all the rights that were that a criminal defendant was entitled to, which are more rights than an administrative, if you will, defendant is entitled to, including a higher burden of proof beyond a reasonable doubt. So this criminal conviction can stand as a basis to suspend a license without a hearing and this 10-year wait period. Now, a new law then was enacted. It was after his administrative suspension that limited the 10-year wait period to drug trafficking offenses. So what did this person do now? 2 years into his 10-year suspension / wait period for reinstatement, he sought reinstatement. And he said, you apply, he argued that the reinstatement petition is a different proceeding than the adverse action that was rendered as part of his guilty plea. So he said the new proceeding applies the current law, which is it's not a trafficking offense. So therefore, I can seek reinstatement now, and I don't have to wait 10 years. And the court rejected that and affirmed the prospective application of the new law and rejected that the reinstatement petition was a separate and distinct proceeding from his sanction. Everybody get that? So come and give me a thumbs up or type in the chats. I followed that because I explained the next case. These two cases are easy to get mixed up. So the point is, the bottom line to this particular case is that the court held that his sanction and his 10-year wait period it applied the day it happened, and a new law doesn't get to change that. Doesn't get to change that, and he was subject to continuing to wait his 10-year period issue. The next case, this case is somewhat the opposite, and I hope I don't confuse this. Osteopathic physician pled nolo, okay, to 1-count misdemeanor of indecent assault of a patient. Okay, and now according to the facts of this case, he did that to rid himself of a trial, and otherwise it was knocked down to a misdemeanor, but it did involve assault of a patient. As part of a criminal sanction, the license was indefinitely suspended. So there's a question right there: is is, can a criminal court suspend a license that is issued by an administrative body? I think the answer is yes, but it gets a little complicated because how do you get that license back? How do you reinstate that? Do you go back to the criminal court and seek a judge? Do you go to the administrative body and allow that decision to make? Or how are you going to handle that? So if I were a criminal court judge, while I might suggest that there needs to be an adverse action against the license, I might defer that to the board and recognize the authority of that board to decide what to do with this license based on a criminal conviction. And my sanctions might be fines and incarceration or something else. And I'd leave it up to the board to get to decide. But be that as it may, as part of his sanction, his license was indefinitely suspended, subject to reinstatement upon showing ability to safely and competently be able to practice. Okay, fair enough. After the NOLO plea, the law changed to prohibit the issuance of a license of a healthcare practitioner if that individual had been convicted of a sexual offense. So it's an across-the-board prohibition, and but it was after his NOLO plea. The petitioner sought reinstatement of his license, and the board denied it based upon the new law. So they were now looking to retroactively apply the new law to this particular candidate. The court reversed that pretty easily, but these are interesting. Both of these are interesting cases to read. Court reversed that. You can't retroactively apply the new law. And here the petitioner had a property interest in a suspended license and is subject to due process. So we've kind of talked about that. Well, suspended versus revocation versus others. So you can do what you think you want with these, but these are interesting cases with, I think it's opposite approaches, well, opposite conclusions, if you will, based upon particular facts. And sometimes, as I like to say now, is if you're not confused, you're not listening. I hope you understood those two cases, but they're very interesting, very relevant to today's topic. So, if anybody has any questions about those cases or retroactive versus prospective application of new laws, feel free to ask those or put them into the chat there. But your reinstatement statement, my reinstatement statement for the day is follow the law, of course, but do the work on the front end, okay? And spell it out. There are future new board members. Reinstatement petitions might be 5-10 years down the road. There may be new laws, new applications, new information requested. If you do the work on the front end, then I think tomorrow's boards will know how to handle the situation, be fairly presented with the factors to look at, and make whatever decision that needs to be made at that particular time. Poorly written, if you will, or silent, let's call them silent board orders, or board orders that don't contain enough information, can really lead to, I think, nuanced or applications for reinstatement that as I've mentioned earlier, might be a thorn in the side of or wasting the time of the board itself. So does anybody have any comments or questions about any of these issues we've talked about, or want to unmute and tell us any issues or stories related to your world? There's a little bit of time left here. I covered a lot of ground, and I hope I made sense in my comments. But questions or comments from anybody or chats? I tried to continue to read some of these chats. And so Rich and Jeff and Michelle, did we answer some of these, or were there any unanswered questions in the chats? I'm kind of looking through them now. Questions or comments? And if not, I will go to this next slide that I like to end my presentations, how I start them, and that a big thank you to FSBPT for what they do as in providing programs and services to you, the regulatory bodies, and you are FSBPT, so don't forget that. Big shout out, thank to the board of directors and staff, but the biggest thanks goes to all the regulators on the line today, and you're all regulators in my mind. You play such an important role in fulfilling the intent of the legislation that you're enforcing, and ultimately public protection. You're not thanked enough, so I will give you a big shout out, thanks, as I turn this back over to Michelle, but I'll stay on if anybody has any thoughts or comments they want to express. So thank you again.
And thank you, Dale, for a great, for me, afternoon of information. If anyone does still have anything that they want to ask at this time, you can put it in the chat. What I do want to do is take a moment to thank all of you and to give a plug for the next regulatory webinar with Dale, which will be April 17th with a focus on board minutes, which seems like a very simple, mundane thing, but is absolutely not and is absolutely foundational. So I hope you can join us April 17th, 4 p.m. Eastern. And don't forget the regulatory workshop coming up in May, the 16th through the 18th, that has hybrid options, in person and virtual. Another great opportunity not to only hear from Dale, but to interact with others from around the various jurisdictions. So with that, Dale, I'm not seeing any questions, just lots of appreciation for today. So with that, I will say thank you, everyone.